Welcome to the Legal Interview Project. The Legal Interview Project is a collection of teens that are working towards building a repository of informational interviews and information for teens interested in getting into law. This afternoon, I'm joined by Joseph Teitelbaum, who is a rising 3L at Cornell Law School and who's also interning at the Harris County District Attorney's Office this summer. It's great to have you.
Pleasure to join you.
Of course. So, what does your day-to-day look like as someone interning at the DA's office in Harris County?
My typical day, I get to the office 8:30 or so, um, and I stop by my court. I am assigned to a misdemeanor court within Harris County, and I just check with my ADA and my chief whether there's any tasks to be done. And then I either sit around and watch what's going on in court. Sometimes it's interesting, sometimes it's less so. And so I'll head to my office and get started on a task. My my goals as an intern at the Harris County DA's office
Mhm.
are primarily twofold. One, to help in any way possible, whether it's something as simple as grabbing something from the office, whether it's doing a substantive legal task, anything that I can do to make the DA's jobs easier, I consider that a win. And the second part of my task, as I see it, is to learn as much as possible. Um, this is the area I am interested in, and therefore anything I can do to learn, whether it's learning about the process of how the DA's office works, or whether it's learning about something substantively legal, um, whether it's learning about some Texas precedent, because I go to school in New York, and I find myself sometimes unfamiliar with specific cases that are unique to Texas. All those things are things that I want to learn, things that I want to become aware of so that it will improve my skills down the line. This is what I want to do, and so I want to become the best I can be at it.
How did you land on being like wanting to be a DA? Like, how do you figure out that that's really what you wanted to do in law?
So I knew that prosecution was something I wanted to do prior to law school. It covered my two legal areas of interest, and it allowed me to participate within those two substantive legal areas. Those two would be constitutional law and criminal law. And my impression thus far is that prosecution allows me to work with both of those areas of the law. Um, and then a DA's office at the state level, it became an area of interest to me after I started attending law school during my first summer. Um, I originally went in with the expectation that I'd be interested in federal prosecution, and the thought process is federal is better than the state level. Why not? It's bigger, it's better. And I had a chance to work at the Middlesex County Prosecutor's Office in that would be in New Jersey, right where I live, um, where I've grown up the substantial part of my life. And throughout that summer, I got a chance to see the impact that a prosecutor can have, that an assistant prosecutor can have on the community on a day-to-day basis. That's not to say that the impact is any greater if you're at the state level, but to me, it seems more consistent. You have small cases that impact somebody within the community, somebody who is victimized by someone who chose to commit a crime. And as a prosecutor, I get to seek justice on behalf of those who were wronged. And to me, a state level is a way for me to more consistently give back to the community.
Wow. A lot of people who are going to be watching this are either doing moot court or mock trial. What advice would you give to people who are, stateside or being prosecutors in different mock trial competitions?
So what I've heard is that mock trial competitions can differ quite significantly depending on where you are locating. So I'm not going to give any technical advice. Um, if you are interested in prosecution, the piece of advice that I have been given from people within prosecutor's office, both in Texas and in New Jersey, um, to me, it was the same substantial piece of advice. As a prosecutor, and this is unique to prosecution, whether it's the state level or the federal level, you have the goal of justice. That means two things. You are number one, going to be prosecuting people who you think are guilty. And if they actually are guilty, your goal is to convict them. But your goal is also to make sure that there are no wrongful convictions. Justice is has two sides to it. And if you have a long-term goal of prosecution, developing the skills to be a straight shooter is, to my level of experience, undoubtedly necessary for a prosecutor. You're going to be held to a higher standard, and rightly so, because you are not just protecting the victims, not just seeking to convict those who did some sort of criminal act, but you're also protecting the rights of the defendant as well. You play a role in the justice system with the goal of achieving justice, and you're the only person within the legal system that does.
What about judges and justices? Would you say that they also seek justice or not necessarily?
Well, so then that's a good point.
Yeah.
They do seek justice, but not as an advocate. They can only deal with the cases in front of them. So if there are a whole bunch of people who are not prosecuted, maybe a whole category of crimes that are not prosecuted, there's nothing the judge can do about it. Judge doesn't get to, of their own volition, decide to prosecute somebody. That is going to be left to the discretion of the prosecutors, who wield great power, but also are the only advocates, let me correct myself, the only advocates within the system who are who have the responsibility of aiming towards the goal of justice.
Interesting. What made you want to pursue criminal law instead of like transactions or something?
For me, um, I think that that is something that for me, it's demonstrated to be something that's rewarding, and it's also something I expected to be rewarding. Because to me, the impact, the ability to help someone who was wronged in some way is an immeasurable it's a unique ability to give back to somebody else within the community. And that sense of community is ultimately what draws me towards the job of becoming a prosecutor.
Oftentimes there's different like in pop culture in different areas, there's dramatizations of how settling out of court works versus how actually going to trial. How many cases would you say in your experience you see actually go through a full trial versus cases that settle with different forms of settlement?
So, anecdotally, in a courthouse, if you were just watching the courts, you would see a lot more cases go to trial. This is because the cases that are going to trial take a lot more time. So if there are trials happening in the courthouse, the ones that are settled might not really be occurring in the courthouse. You see a lot of cases going to trial. That being said, when I was researching different areas of law prior to while I was applying for law school, I was struck by the number of cases that are settled within the criminal realm. The number for federal prosecutions, at least at that time, was 97, certainly higher than 90%. I am not certain about the 97, but over 90% of criminal cases were settled within the federal court system. And apparently the number is almost as high in certain states. So that's a almost shockingly high number of cases that are settled outside of the court without necessarily having any trial whatsoever.
Do you think that's a positive for the entire legal system within the criminal realm?
It's certainly inevitable. There are a limited number of resources to go around, and so long as there are that many more crimes than there are resources to prosecute them, there will have to be some sort of balance, some sort of efficient use of those resources. That being said, to me, the ideal, if we had an unlimited amount of resources, would of course be everyone should get a trial. Why? Because to me, the trial grants the defendant the ability to um, exercise their rights. And as a prosecutor, my goal is to seek justice. And I would be more likely to see justice done if it were decided by a jury of the defendant's peers, of our peers.
Yeah. If everyone like in this system, in this ideal realm with infinite resources, everyone goes to trial, what would the interaction be? And I guess in a day-to-day, what's the interaction between the prosecutor and the public defenders? What's Are there people that do both, or is it really just like two strictly different career paths?
I would assume, and this is an assumption on my part,
Yeah.
um, that prosecutors will become defense attorneys, um, and defense attorneys may also become prosecutors. It's a very similar skill set because you're operating within the same courtroom, hearing the same cases, coming up with the same strategies. And as a prosecutor, you want to examine what strategies the defense might use. And as a defense attorney, I assume the same thing applies. You want to examine which strategies the prosecution might use. When you're sitting there thinking about cases, about the strategies that both sides are going to use in order to successfully uh, prosecute or defend the case. You are going to develop this a very similar set of skills, which can transfer fairly easily from one to the other if someone is interested in doing that.
Okay, I guess more in a day-to-day fashion, are people like, obviously everyone is cordial and respectful in a courtroom, but are people like friends, with like prosecutors, friends with public defenders, or is it really just like two entities that are both public offices of representation, but they're different, like different worlds?
So, prosecutors and defense attorneys, and I say defense attorneys generally because I
Yeah.
don't know the individual people well enough to distinguish whether they're a public defender or whether they are a defense attorney. They they tend to have a cordial relationship, um, often a friendly relationship. People do switch between one and the other, and
Mhm.
because of that, often these are longtime work friends that people have known for a decade, 2 decades. And I think it's inevitable that within the legal system, there will at the very least be a cordial relationship. And I think within the two very similar systems, the prosecution and the defense, where the skills are transferable, it is almost inevitable that there will certainly be some friendships between the two sides.
Yeah, I guess going back, a bit of a different topic, but going back to say when you were a junior in high school, what did you want to do? What were your university plans? What careers were you looking at? What was like going really far back? What was that time like?
So as a junior in high school, I knew I was interested in law, specifically in prosecution of some sort. I
Hmm.
was open to other possibilities, but to me, the goal was an undergraduate degree that I would be interested in pursuing, that I would be successful in pursuing, with the end goal of taking that education and furthering it as I applied and went to law school.
Were you K to JD?
I was not. I had a gap both before and after I graduated my undergraduate degree. Largely, it was, I would say, a mistake on my part. I took a year off after undergrad because I was studying for the LSAT. As as you may be aware, the LSAT is one of the two potential tests, one of which is a cornerstone for an application to law school. And I just didn't have the time to study for the LSAT while I was in undergrad. So I had to take an extra year to study for the LSAT, take the LSAT, wrap up my application before I could start law school the following
What
year.
would be the second test for law school applications?
That would be the GRE. It's
Yeah.
a more general graduate test used for various different industries, and it has become more accepted amongst some law schools that you can use that instead of the LSAT.
Interesting. I guess where did you go to university? Which place fulfilled your goals and what major fulfilled your two goals?
So I went to Truro University, which is located in the city, and I went to specifically a division called Lander College for Men in Queens. For me, this was an easy choice because it it was a dual curriculum school, both Judaic studies and academic studies, which I had pursued throughout my education, all the way from elementary school through high school. And continuing with that sort of education was an easy decision for me. Um, I decided to major in political science. It had been an area I had long been interested in, and they had a stellar program which I was able to pursue as I set my sights on law school.
Very cool. Who are some political philosophers that you find yourself resonating with?
So I had, perhaps this was my favorite class in undergrad. It was a class called Introduction to Political Theory. And we went through eight political theorists, starting with Plato, ending with, I think it was Tocqueville. Um, and I really enjoyed Aristotle, specifically his thoughts on crime.
Yeah.
No surprise there. But to me, the theorist that I found most resonated to me was a political theorist by the name of Benjamin Constant. He was a Frenchman, and his brand of politics would, by my characterization, best be described as libertarian, early libertarian. Um, and I found that read fascinating.
Do you find it to be like two sides of the same coin that there is like in libertarian philosophy, there is a limit that you do need people like prosecutors and a court and a judge, and like you do need some order even within a libertarian society. Do you find that to be something that sort of comes up a lot?
Um, that balance between law and order and having the government take a hands-off position when it comes to crime, when it comes to general issues of limited government. To me, the balance can be characterized by looking at how Aristotle characterized crimes. You have, according to Aristotle, two types of crimes, malum inse and malum prohibitum.
Hmm?
These are translated to crimes that are crimes because they are inherently wrong, and crimes which are crimes because we proclaim them to be crimes. So, for example, it would be a crime to murder. That would presumably be because that's inherently wrong within a Western society, within, I would argue, any moral society that values the life of human beings. And then you would have certain rules which may not inherently be required. Um, for example, we all know we need to drive on one side of the road so that we don't crash into each other, but why does it need to be the right? It's because we proclaim it to be the right side of the road that it must be enforced. But it could just as easily have been the left side of the road, as you can find in, at the very least, some European countries, as far as I know.
Yeah, and I guess what happens if someone drives on the left side of the road intentionally? I guess that turns into a crime that's prohibited, like not prohibited, but it's wrong by nature, like driving uh, your car face first into some other car, right?
Well, so it would be a malum a malum inse. Sorry, it would be a malum prohibitum, a law where we prohibit it because we declare that it's prohibited to drive on the wrong side of the road, to drive on the left side of the road. But there's something inherently wrong about driving on the wrong side of the road because we all know that that can cause some risks for other drivers, for yourself, for bystanders. That sort of choice by someone would put others at risk. And I think it would be inherently logical to prevent society from putting others at risk in that sort of manner.
Yes. So if someone like just driving on the left side of the road is a convention, but if someone doesn't accord to convention, it almost leads to crashing into someone else intentionally, which I assume would be categorized as murder in this scenario, right? So like
Assuming that were the result, yes.
assuming that was the result, how do you handle justice and how do you advocate for justice in the most just way? And how do you attempt to not have people who are wrongfully convicted?
That's a good question. And I think it starts with gaining experience because I can look at a case as an intern and have all sorts of ideas about it. Um, and I could be way off base, but somebody who has had 20 years of experience can then take a look at that same case and their level of understanding of the case, of the issues that the defendants may have had that may have led the defendants to commit whatever the crime may have been. Um, and the level of understanding of the case to know that maybe the defendant didn't commit that sort of case. I think a lot of that comes with experience. I think that somebody with 20 years of experience will be able to take a look at a case and immediately have a better impression of it than me. And therefore, for me, step number one is to gain some of that experience. Whenever there's somebody who is willing to explain what their thought process is when evaluating a case, um, what their initial reaction is when they first see the description of what happened. That is a chance for me to learn, to develop my experience so that I can make some of those more intuitive decisions more accurately because I have had more of an exposure to those sorts of cases.
In law school, do you have a lot of classes on sort of ethics and how to handle things with like the utmost regard for the law and for the just operation of the legal mechanism?
So we have a class called Professional Responsibility, which is geared towards um, teaching law students the required ethics for a lawyer. But beyond that, I think ethics are an issue that come up in class that are discussed as we debate some major precedent and the the major thought process that drove the judges or justices to come to the result, to the outcome that they chose. I think that ethics are always an undertone, a part of the analysis of a case, of a major precedent.
What's been your favorite class in law school so far?
So I earlier mentioned my two favorite areas of law. Um, for me, that's constitutional law and criminal procedure and criminal law. And for me, the class criminal procedure at Cornell, they break it up into two classes. There are criminal procedure investigations. That's the rules of criminal of the constitutional guarantees that a defendant would have from the time where they are suspected of a crime all the way through when the investigation ends. And then there's adjudications, which starts when the investigation ends, all the way through the conclusion of the adjudication for the defendant. For me, that class, those two classes were my favorites because they combined constitutional law and criminal law. You have the rights of the defendant under the United States Constitution and under the state's Constitution, um, as well as any laws which may have been written to protect defendants. There are also laws to protect victims, to limit the powers of prosecutors. All those laws, that whole category of information is exactly what I find most interesting within the law because it marries my two areas of interest.
Within those two areas of interest, what would you say are like some capstone must-read cases?
So I'll start off with a case that I think was erroneously decided. That
Yeah.
would be Miranda and its line of cases all the way through Dickerson. Everyone is well aware of their Miranda rights, but I think that if I were to challenge you to find those rights written into the Constitution, you might be hard pressed to find them. Certainly not within the Fifth Amendment, which is where the Miranda rights ostensibly come from. As a result, I conclude that Miranda is an erroneous decision. Perfectly great idea, maybe, but it should have come from the legislative branch. That being said, the
Could the
fact that it's an
judicial
error makes
then
it scintillating.
could the
What?
judicial, let's say the legislative branch, it adopts Miranda rights or whatever they're called because we don't have a guy named Miranda, right? So the judicial branch, the legislative branch writes these laws. Would you say then that judicial has the authority to overrule them because there's no constitutional precedent?
So the Constitution is geared towards protecting
Mhm.
the defendant, and a case like Miranda was, I think, erroneous because it oversteps the bounds of the Constitution. That would be an error for the courts to do. However, for the legislative branch, they're free to make any laws protecting the defendants they would like, so long as they also don't violate the Constitution. For example, if they were discriminatory in nature, they might violate the 14th Amendment. If they were, if they violated due process, they might violate the Fifth and 14th Amendment, both of which guarantee due process under the law. But to provide extra process won't really be any issue. I don't foresee any constitutional challenge towards extra protections for the defendant. The only limit for Congress might be that they might not have the authority to propagate these rules for the states. States might have the choice to limit, states would have the choice to limit the rights guaranteed to defendants within their states to the outer bounds of the Constitution.
Interesting. A big issue in Miranda was the fact that different police stations had like restrictive or really almost abusive policies on how to handle defendants when they didn't know their constitutional rights. Doesn't Miranda sort of like find that? Would you say that the issue with Miranda is that the Miranda rights that are read are not found in the Fifth Amendment?
Yes, the decision was pretty clear that they were a set of rights arising from the Fifth Amendment, and I think that that overstepped the boundaries of the Fifth Amendment. That being said, it, it to me is very interesting that the day after Miranda was decided, front pages of newspapers we're decrying the decision of Miranda as being way too lenient for defendants, and we're going to result in some sort of increased criminality within the country. And that really hasn't proved to be the case. And if you take a look at confessions have maintained at more or less the same rate since Miranda. And as a result, to me, it draws a question to the policy itself, whether Miranda was beneficial. In class, the
Mhm.
professor posited potential solutions that policy-wise would perhaps protect the defendant better than Miranda has. So for me, I find two problems with Miranda. I find number one, the constitutional issue might have been wrongly decided. I think it was. And then I also take issue with the policy because it's proven since then to be pretty ineffective at its stated goal. And if the goal is to protect defendants, I think that if it's outside of the bounds of the Constitution, it needs to come from the legislature. And then I also think that if the legislature is going to create some sort of protection for the defendant, they ought to do a good job. Protecting them in a way that isn't really helpful to the defendants isn't very useful. So I doubly critique Miranda.
Interesting. Do you think that there could be a overturning of Miranda in the future?
So I mentioned Miranda and its line of cases ending, I think, with Dickerson. And that case was a challenge to Miranda, which very surprisingly got decided in favor of Miranda. They, the decision within Miranda itself said that these protections were essentially going to be bestowed whole cloth on the defendant, um, so long as the government or the states didn't come up with a better solution. And Congress immediately passed a law essentially trying to undo the Miranda decision. The law would essentially go back to the previous standard and say that the defendant has the rights prior to Miranda, but that they don't actually have Miranda rights. Um, the process would be that if you wanted to admit the results of an interrogation, you would have to use the same standard that was available prior to Miranda. And surprisingly, because of the constitution of the court at the time, but it was the Chief Justice at the time, wrote the majority opinion and wrote it in favor of of Miranda, and the ruling in Dickerson upheld Miranda as a constitutional right. So it's possible that this case could be overturned in the future, that Miranda could be overturned in the future, but it would require overruling Miranda and Dickerson.
Interesting. So how do you balance in a theoretical and then in a practical environment, how do you balance the rights of the victims and the prosecution with the rights of the defendant who is it presumed innocent until proven guilty? How do you preserve those rights without overstepping the Constitution?
So when it comes to the job of a prosecutor, Miranda may have been erroneous. Dickerson may have been erroneous, but that doesn't matter. The Supreme Court decided that the defendant has those rights, and those are rights that, as of today, are rights whether they were bestowed or accurately found within the Constitution. They are rights that are guaranteed to the defendant, and the job of the prosecutor is to work within the bounds of the Constitution.
Mhm.
Therefore, the prosecutor is going to respect those rights, even if they are someone like me who thinks that it was a wrong decision. The responsibility of the prosecutor is to work within the confines of the law, and Miranda and Dickerson today are the law.
Very cool. I guess sort of on a closing note, what advice would you give to young prosecutors who are or young people who are thinking about becoming prosecutors or thinking about going into criminal law or law more broadly? What advice would you give to those people?
My advice would fall into two categories, depending on whether the person is already applying for law school or in law school, or
Mhm.
whether they are in some earlier stage. So if you are in an earlier stage, be it elementary school, middle school, high school, or even undergrad, and you haven't yet started with the pursuit of your legal career, I think that your goals should be twofold. Number one, you are interested in law, double check that. It's law school is useful for one thing and one thing only, and that's the pursuit of some sort of legal career. It's not some sort of general degree that might be useful in a whole bunch of varying industries. So take the time to check, meet with a lawyer within maybe your particular area of interest, or even if you don't know your area of interest, meet with a lawyer who is somewhat local to you. We are all happy to chat. We are typically willing to take some time, perhaps over some coffee, to help you understand more about the law industry and to share our experiences. So, number one, if you're in high school, undergrad, somewhere earlier, make sure that the law is something you're interested in and that you have a full understanding of the law so that you know you're actually interested within some sort of aspect of the legal field. And if you are in the application process currently, um, the two main aspects of your application are going to be your undergraduate GPA and your LSAT score, or if you take the other test, whatever your score is, that's going to make or break it. Those two factors are quantitative, and because law schools are ranked, those two factors are going to determine what options are available to you. And my last piece of advice is remain flexible. Feel free to change your mind. You may be interested in law today. You don't need to be interested in law tomorrow. So keep your options open. Learn what the legal industry would actually require of you, whether it's something you would want to do, and then go ahead, pursue that aspiration, that goal.
I wish the best of luck to anyone watching this. Bon voyage, and thank you for sitting down with me this afternoon. Thank you.
My pleasure. Thank you very much.